Are there any other questions from the
Yes,
panel?
Council. And the question regarding how far can a de facto member continue on and remain de facto? And I think I'm raising this with respect to the fact that the resolution has not been resolved. There was no resolution ever presented to the board regarding the way the process and the appointees were nominated. How far can is your position then that absent that resolution, still the council or the GEC members can still do or proceed with official business of the commission?
I have several thoughts on that, Justice Demapon. First of all, I'm not so sure that the state of the evidence credibly shows that those party resolutions did not exist. But if you're asking the questions, and I still don't believe it was the spirit and intent of the law to allow this court to nullify an election or decertify members of the commission for the mistakes of a private association. I don't know where this court would draw that line. I just find it very hard to imagine that the mistakes of basically this political party, non-governmental entity, is enough to usurp and stop a law election.
The reason why I asked that, Councilor, is it's very clear in your statute that there's a need to have that resolution.
Yes, sir.
And we cannot say that, well, it's a mistake or what. It's part of the process, and that is part of the legal process. And I asked that question simply just to say, clarify from your side, clarify to me and to the board. At what point we say that, okay, we don't need resolution here, we can still have a functioning council or commission without having all the resolutions that are required by law.
I don't know where this court would draw that line. I don't know if there's one finite, defined line that can be drawn in every single circumstance. I think the unique circumstances in a particular case will determine where that line should be drawn, and that judgment should be made by this body. But what they're complaining of is not a mistake of the Guam Election Commission. It's not something where they're coming in saying that there was dereliction of duty, there was a mistake by the GEC. Here, with regard to the 4 members whose only fault was lack of a party resolution, what they're really saying is that the party was the one that messed up. The chairman was the one that didn't follow their internal rules. And therefore, that should not be held and attributable to the Guam Election Commission, because it's not their fault. Would the Guam Election Commission know? I say not always, because sometimes they're given CC copies of the party resolutions, but as the law points out, that resolution goes from the party to the governor.
But what about the appointing authority? Shouldn't the appointing authority ensure that his appointment is made in conformance with the law, and which requires a validly passed resolution? In fact, this happened in the past where nominees that have been transmitted to the governor have been rejected because it hasn't been accompanied by a validly passed resolution.
That is a possibility, Your Honor, and I will leave it to this body to determine where to draw that line. But certainly it's not the Guam Election Commission, because that resolution goes to the governor. And again, I'm not so sure that the facts draw out that fact conclusively.
Questions? Panel has no further questions for you, Mr. Cabot. Thank you very much.
Thank you.
Mr. Phillips.
Mr. Chief Justice, and may it please the court, why are we here today? The people of Guam have spoken, and what we have simply is a collateral attack on qualifications based on the verdict of the people of Guam. If the people of Guam had chosen different, then we wouldn't be here. We're here reviewing a certificate and certification of election results, but the whole battle here is a collateral attack on the qualifications that really, to address your question, Justice Dimapon, the line drawn is prospectively. And unless, and I'll be the first to admit exceptions, when there's bad faith and fraud and other things that have been listed, they cite the Hoboken case and the White case and they're very distinguished. But at the same time, what jumps out, I think, at all the briefing is you don't find any jurisdiction that says that they've not applied, considered, adopted the de facto officer doctrine. The best they can say is our Supreme Court hasn't, because they can't say our Superior Court hasn't. It has very well. In fact, it was the Lujan case that I think is closely on point.
But
it goes all the way back to the Guam Congress.
They argue, though, that there might be two exceptions that would be applicable in this case. One is that the doctrine is inappropriate because there was an intent to protect the individual's candidates here by having the passage of a duly passed resolution. That's one argument. So under those circumstances, the doctrine could apply. And the other is that there's some semblance of bad faith in assuming the office by the members because this problem has persisted for a significant period of time.
With all due respect, Mr. Chief Justice, I think Mr. Cabot clearly pointed out, if there was an error, and I'll address this in a second, I mentioned this earlier to the court, the last appearance, if there was an error, it was at the level of the party, the chair or the party, depending on how they handled it, made the nomination to the governor, but the governor made the appointment. And so what happened in between, there's no evidence that it can be attributed to either the GEC or the GEC members. Mr. Cabot pointed out that they sometimes receive resolutions and other times they don't. I have mentioned to the court, and I can state as an officer of this court, in my 3 terms as Democratic Party chair, I did not use a resolution, but I always got the consensus of the body, and the case law shows that the resolution does not have to be in writing. Would the court say that's not a resolution? It was duly passed, and we moved on. And so a number of those members I think I appointed. But that I don't think the court would find problem with. I think what they're talking about is a unilateral usurpation of that power. And generally
so
that...
you're saying the governor can rely on the letter or whatever communication he receives from the party chair?
I'm saying first, Justice, that the facts are not complete here, because I think that would make a difference. And yes, I am saying that the representation by the parties is something that the governor should be able to rely upon. First question is, well, if the governor doesn't know, then our court doesn't know. I mean, it's a real awkward position to be in, where unlike all the cases that have been cited, where there's either stipulated facts or findings of facts by lower court, we have nothing here. And by the existence of no evidence, there's an assertion that it therefore means something. And I think that's a mistake. Governor Gutierrez and Senator Uggan, to their credit, they don't dispute the results of the election. What they're saying, though, in a backdoor method, is saying, well, we have a problem with the certification and the issuance of the certificates. With the issuance of the certificates, they concede it will affect many other elections.
But how would they approach this under our election code as a challenge if they wanted to do so directly, as opposed to doing a backdoor method?
Yeah, that's a very good question, Mr. Chief Justice, because the first thing they could not do is appeal to the Guam Election Commission. You asked us to brief whether or not there was an appellate process. There's none. I think we agree with petitioners there. So that's why Article 12, or Chapter 12, excuse me, 3GCA provides that process for an appeal.
Where does it provide it under the specific causes to contest this election? I know last time you talked about potentially under B for misconduct, but when I go back and look at that, it seems to be limited only to misconduct of a precinct board or members of a precinct board, and not misconduct of any election commission member.
And assuming you're correct, the adequate remedy of law doesn't stop there. It would have been bringing a writ at that moment in time to answer that question. But the attack...
Well, the moment in time was when they discovered that the members weren't appointed, and they brought a writ rather quickly afterwards.
Well, there's 2 points there, Mr. Chief Justice. Number one, in the very case they cite, the main case cited within there, I believe it's Fincher or Fish, states that that is the easiest piece of information to obtain. And generally, that's done ahead of time. And so in this case, if Governor Gutierrez had won, then there would be no problem and we wouldn't be here. So the search wasn't because they had a real problem with qualifications, it's because they're looking for a way to defeat the decision of the people of Guam. And that, I can't say in more clear words, is a collateral attack. And in Judge Diaz's words, you can't do that in these proceedings.
Well, they're not asking that the vote be redone.
Well, they're not doing that because that obviously is a remedy that would not exist. So what they're doing is tantamount to that, and it's very important, Mr. Chief Justice, to look at what they're asking for. They're saying they're looking for another group of people to do what the legislature has mandated is nothing more than a ministerial obligation. You could have the three of us here sit, and we would have to come to the same conclusion. In fact, you could have Governor Gutierrez, Senator Uggan, and Jerry Gutierrez sit, but their obligations would be the same. And with all due respect, I submit to the court, that's why today the Democratic members refuse to show up for a meeting, because they understand Joshua Tenorio and John Trelawney and Alice Tyron all raised their hands in support, not because they like the results of the election, but like I have, I've lost elections when I'm on the commission. I raise my hand because it's a ministerial duty. They cannot go back and call another recount.
But where under Title 12 can they bring this cause of action?
Well, first of all, as I said, they could have brought a writ, and they failed to do so.
But they did bring it. You're talking, I mean, they brought it after they discovered the situation.
Right, and the situation, Your Honor, goes to the certification and it goes to the issuance of the certificates, not a collateral attack on the qualifications of the member. Because I'll tell you what happens on election night when we all go home at 6 o'clock. The losing team will all head to GEC to see if they can find something. And that's all what's supposed to happen ahead of time if that is a concern to you. Otherwise, the whole de facto officer doctrine goes up in smoke. You're supposed to rely on the people like yourselves, like justices that may now, or judges, excuse me, one justice and one judge who may not be retained. But we're presuming they are, and although I'm not going to bet on it, I think Judge Sokola has probably sentenced someone between now and then, and whether it's Yang or other cases we've cited, those are to be upheld. And there's some tight exception to that with regard to the appointments clause in Ryder. But although Ryder found that, and that's a Supreme Court case, found that it was inapplicable, it gave great testimony to why it works. And the bottom line here is it's supposed to prevent the chaos that this has created. Mr. Chief Justice, I'll be the first to say that Carlo Branch should be congratulated. Because of Mr. Branch, I doubt we'll ever have a lapsed appointment, probably in any committee or board or commission on Guam. But that's where it needs to stop. In the elected school board case that we won, technically Randy Cunliffe won because he proved that the districts were all out of whack. But the remedy was prospective. The remedy is we will ensure this never happens again. The remedy here is to ensure that this board doesn't do this again. And they've cited one case, the White case, where that's exactly what happened. And in that case, the group just totally disregarded what the judge said. They went out and conducted the election, didn't put the guy's name on the ballot, and then their actions were in essence null and void.